Welcome to our seminar on the Finch judgment, which will include a discussion about what the judgment said and then consideration of its implications for the future. We're delighted to see so many people joining us, and we hope you find what we have to say informative. I'm David Elvin, KC. I'll be chairing and speaking a little later, and I'm joined by my colleagues, Richard Moulds, KC, Matthew Fraser and Nick Grant. So to begin, it won't have passed anybody by that this has caused something. This judgment has caused something of a stir. We have been waiting for some time for this judgment, and the Supreme Court handed down a day before the first anniversary of the hearing, which was on the 21st of June and 22nd of June last year. So we'd gathered that all was not straightforward. And as you see from the judgments, there was a very strong dissenting judgment from Lord Sales and Lord Richards. We're going to begin with a general run through of both the majority and the minority judgments. And Matthew Fraser is going to begin with that, with the majority judgment. Matthew acted as my junior, in fact, for Horse Hill Developments throughout the Finch case. He's got a wide-ranging practice in planning and environmental law. Other recent cases he's been involved in, acting for Save Britain's Heritage in the Marks and Spencer's Oxford Street case, and in the both at the inquiry and the High Court challenge. He's a member of the Attorney General's B panel of counsel, and EIA is bread and butter to him, both at inquiries and in court. Matthew, please.
Thank you very much, David. I'm going to start by discussing the majority judgment. That is the judgment of the 3 out of the 5 judges in the Supreme Court who heard this case. Just to begin with, if it might help just to outline in a nutshell, in a single sentence, what was concluded, and that is that in carrying out an environmental impact assessment of a project for the extraction of oil, the authority is required to assess, as an indirect effect of the project, the environmental effects of greenhouse gas emissions arising from the ultimate combustion of the oil once refined and used as fuel. So for those who have got a busy Monday morning, you just want to know exactly what was decided, that is it in a nutshell. The background we can go through pretty quickly. It all started with a grant of planning permission in as long ago as September 2019 to drill a well and then operate that well for the commercial extraction of oil on a site in Surrey. It was then challenged in November 2019, and when it was considered on the papers as the initial stage in a claim for judicial review, the judge found the claim to be unarguable. So not just that it was wrong, but that it was unarguable. That conclusion was then also reached when the claimant applied to renew their claim for judicial review at an oral hearing. The judge also found that the claim was unarguable, and it was only when the claimant took her claim for judicial review to the Court of Appeal that Lord Justice Lewison granted permission for the claim to proceed, which meant it then, in a sort of strange procedural move, goes back to the High Court then, who then considered the issue substantively. That was when we got Mr. Justice Holgate, now Lord Justice Holgate's judgment in December 2020. That was a decision to dismiss the claim, holding that the greenhouse gas emissions from end-use combustion cannot, as a matter of law, be indirect effects of the extraction project. There was then an appeal by Sarah Finch against that judgment, which was determined by the Court of Appeal over a year later by a 2-1 majority, which dismissed the appeal of Sarah Finch, therefore maintaining the decision of Mr. Justice Holgate to dismiss the claim for judicial review, but with the majority finding that the council, rather than being obliged as a matter of law not to take into account these greenhouse gas emissions was entitled, as a matter of planning judgment, to regard those emissions as not being effects of the extraction project. And there was a dissenting judgment from Lord Justice Moylan. The claimant, Sarah Finch, then appealed to the Supreme Court, who granted permission in August 2022. It was then nearly a year later that the Supreme Court heard the appeal in Finch. And as David alluded to earlier, it took them almost exactly a year to consider the arguments and reach a verdict, allowing Sarah Finch's appeal by a 3-2 majority, with Lord Leggatt, Lord Kitchin and Lady Rose in the majority, and Lord Sales and Lord Richards dissenting. And Nick will take you through the dissenting judgment of Lord Sales, and I'm going to focus on the judgment of Lord Leggatt. But I think it's interesting just to note, as a matter of background, that whereas Lord Leggatt, in paragraph 7 of the judgment, decided that the answer to this case was plain, it was also the exact same answer was found to be unarguable by 2 High Court judges earlier. So how something can be both unarguable and plain is slightly beyond me. So anyway, the majority's reasoning, I've tried to just distill it. It's 170 odd paragraphs long. I've tried to distill it into just a number of key points. For those of you who have got busy practices and haven't got the time to read through the entire judgment. But fundamental to Lord Leggatt's analysis was that was to focus on the purpose. Why do you extract oil? It's to make hydrocarbons for combustion, and he thought that was very important. The second point then is that once the oil has been extracted, it is a matter of inevitability that the carbon will sooner or later be released into the atmosphere and contribute to global warming. There's no uncertainty as to that future outcome. And the judge found that in the great majority of cases, the question of whether something is an effect of a project admits of only one answer. And so contrary to the way the Court of Appeal had analysed it, is not a matter of judgment, allowing for different approaches to be taken by different authorities, potentially with significant inconsistency. And his analysis was that whether something is an effect is fundamentally a question of causation, because an effect is, in his words, the obverse of a cause. And in the present case, there was no doubt about causation, in the sense that it was not only a likely significant effect, which is the threshold for EIA purposes, but an inevitable effect of extracting the oil from the ground. And the effect, he also noted, can be readily assessed using an established methodology, which won't always be the case for other raw material extraction. He then reasoned that combustion emissions that will occur elsewhere as a consequence of the operation of the project to extract oil aren't direct effects of the project, but are indirect effects. And so that would mean that greenhouse gas emissions would be a category of that, because of course nobody knows where in the world those emissions are going to be taking place. Climate change is, of course, a global problem, and the relevance of greenhouse gas emissions caused by a project does not depend on where the combustion takes place. That it doesn't reduce the extent of the emissions depending on whether it's extracted in Europe or in the Southern Hemisphere or wherever. The greenhouse gas emissions from combustion are not outside the control of the extraction operators, which is something that the High Court and the Court of Appeal had found. Because, as Lord Leggatt saw it, if no oil is extracted, then no combustion emissions will occur. So that was his approach to the question of control. The effect of the combustion emissions, he then also said, does not depend on when or where the combustion takes place. He also considered the argument that was being raised that there were non-planning regimes which exist outside of the realm of planning control that will mitigate or operate effectively so as to mitigate the impacts. But he, 2 points on that. Firstly, his analysis was that assuming that non-planning regimes will operate effectively doesn't remove the obligation to actually assess the effects of the project, which can be assumed to be mitigated. It doesn't obviate the need to include those effects in the EIA. And in any event, no such regime arises in the present case. He saw no justification for restricting the scope of the assessment to greenhouse gas emissions that are occurring at known locations or related to the site. He also rejected the significance of there being an intermediate process of refinement. That was something that some parties during the proceedings had been advancing, that because the oil, once extracted, essentially cannot be used as fuel and combusted without going through a separate process of refinement, which itself is an EIA project, that had some significance. He disagreed. He said that it doesn't alter the basic nature and the intended use of the commodity. Since it's inevitable, the process of refinement doesn't breach the causal connection between the extraction and the use of the oil. He also did not see there any significance in terms of any floodgate and uptype argument, which again had been given some momentum, certainly in the judgment of Mr. Justice Holgate. He saw oil as being a different commodity from iron or steel, which may, once extracted, have many different uses and be incorporated into many different end products with what he described as innumerable downstream decisions, making it impossible to identify which effects are likely or to assess them. But he said oil was in a different category to those. And then in terms of the manufacture of components for use in the construction of cars and aeroplanes, the judge said the view might reasonably be taken that the contribution that is made by a single part is not material enough to justify attributing the eventual impact of the whole overall, for example, aeroplane on that individual component. The judge also, as I said, concluded that it was not relevant that the oil refinery is also EIA development, because the same effect can be attributed from more than one activity or the same project that is going through different stages. He then memorably said, outside the realms of Kantian metaphysics, there is no such thing as, quote unquote, the development itself, which enjoys some sort of separate noumenal existence. This took me back to the days when I was studying philosophy at university. And I have to say that even with the benefit of a philosophy degree, I'm not entirely sure what the judge means by that. He then looked a bit at what the Court of Appeal had said the correct approach should be. And obviously Sir Keith Lindblom in the Court of Appeal had emphasized the need for a sufficient causal connection between project and effect. And he said that would leave decision makers, quote unquote, completely adrift, as well as being intolerably vague. The existence of intervening stages does not deny the clear and inexorable causal path between extraction and combustion. Therefore, there was, in the judge's analysis, no basis upon which the council could reasonably decide that it was unnecessary to assess combustion emissions. He then also dealt with arguments relating to consistency or otherwise with national policy, finding that taking account of adverse effects on the climate is not inconsistent with national policy, which requires great weight to be given to the benefits of extraction for oil, and that there was nothing inappropriate about an individual planning authority taking into account the effects on climate of greenhouse gas emissions from combustion. And this is not something which can only suitably be addressed at a national level. And you'll hear from Nick shortly that Lord Sales reached very much a diametrically opposite view to that. He then went through some of the case law which had been cited, not finding any of it of significant assistance, it must be said, because there hasn't been any case which has directly determined this point that would have been of significant assistance to the judge. In relation to Abraham and Kilkenny cheese, which I haven't got the time to go into, the judge found that they could be distinguished from the present facts, but that Squire was very similar to this situation, that there'd been an indirect effect which had been unlawfully excluded in Squire. And he found the same to be the case here. He also found that a Norwegian judgment called Greenpeace Nordic was persuasive and one that he agreed with. So overall, then, a conclusion that the council's decision was unlawful because the EIA failed to assess the effect on climate of the combustion of the oil to be produced. And I've just noted at the end there, as I said earlier, that the majority found it plain what the answer to this case should be, albeit taking 174 paragraphs to do so. So we'll now hear why one answer, which is plain to 3 judges, is very much not plain to the other 2. Thank you very much for listening.
Thank you, Matthew. As Matthew's just indicated, Nick is going to deal now with the dissenting judgment. Nick's a planning and environmental law specialist. Recent cases he's been involved in as junior counsel to Richard Moores in Finch, and of course in last Friday's CG Fry case on nutrient neutrality, which was handed down late in the afternoon by the Court of Appeal, and the Caldwell case on enforcement notices. Outside the High Court context, he's represented Natural England in the Lower Thames Crossing DCO, part of the team promoting the Seneca Solar Farm DCO, and he's ranked as a leading junior in both planning and environmental law in the Legal 500, and has recently appeared in Planning Magazine's list of top planning juniors and top planning juniors under 35. Nick, over to you.
Thank you, David. So I'll pick up with the dissent of Lord Sales and Lord Richards. It's a longer judgment than the majority judgment. In a nutshell, Lord Sales and Lord Richards say, yes, climate change is bad, but the EIA directive, like any statutory instrument, has limits. And what the majority finds is, frankly, going beyond those limits. Although it is longer than the majority judgment, it's one that's blessedly free from Kantian metaphysics and reference to noumenal existence. And I'm afraid, without the benefit of a philosophy degree, I really struggled with what that meant. So Lord Sales begins his judgment with general introductory matters, scopes 1, 2, and 3, GHG emissions, although he notes that neither the EIA directive nor any CJEU decision actually uses those concepts. He outlines the factual background and the history of the challenge, which Matthew has helpfully gone through, and then comes to the history of the EIA regime. Starts off with the 1985 directive, noting that the key language central to this appeal, which is in Article 3.1 and is significant indirect effects, was taken from that 1985 directive. The 85 directive predates the GHG protocol in reference to Scope 3 downstream emissions, and that language was adopted by the EU before the GHG protocol was even a glimmer in the eye. He then moves on to the current EIA directive and notes that that was in fact intended to codify the 85 directive in the interests of clarity and rationality. It postdates the GHG protocol, which is what introduced Scope 1, 2, and 3 emissions, but again, doesn't adopt the language of Scope 1, 2, or 3 emissions, and instead reenacts the same basic concepts. Now, those concepts include that the purpose is to assess the significant environmental effects of the project, that there is a definition of the project, which is the execution of construction works or of other installations or schemes and other interventions in the natural surroundings and landscape, including those involving the extraction of mineral resources, and that the directive allowed the EIA process, indeed envisioned the EIA process being integrated into the existing procedures for development consent in member states, which often meant throughout the EU it's implemented by various equivalents of the planning system at local authority level. He then moved on to the 2014 directive, which specifically that certain references to climate change and greenhouse gas emissions. So Sales considers in details the background of that. There is a 2012 impact assessment published by the Commission, and although he goes through it, he says effectively there isn't anything in here that says Scope 3 emissions have to be included in the EIA directive. They're not seen as a shortcoming of the old 2011 EIA directive. In advance of the 2014 amendment, the Commission then published guidance on integrating climate change and biodiversity into EIA. That's the 2013 guidance I refer to. And again, even Sales notes that even though there's a section talking about understanding key climate mitigation concerns with examples of questions to ask project promoters and developers, these include questions on indirect greenhouse gas emissions, like will the project influence demand for energy? Is it possible to use renewables? But again, there's nothing in here about Scope 3 downstream GHG emissions having to be included. The focus instead is on the increase and decrease of greenhouse gases closely associated with the project. And he keeps coming back to the definition of the project. Similar points arise from then the amendment to the 2014 directive and the 2017 guidance published by the Commission thereafter. On the Aarhus Convention, although he notes that it was influenced by the 85 directive and goes further, again, there's nothing in any of the published Aarhus decisions, either of the Compliance Committee or in the Implementation Guide or any of the other published texts or legislative history that deals with this point. So against that background, he goes on to examine the national policies on climate change and planning. I'm sure this will be familiar to many of you, the Climate Change Act and the target. It introduces the fact that the Secretary of State's got to publish and submit statements on how to, has to publish carbon budgets and submit statements on how we're doing as a nation in meeting those budgets. The EU's effort sharing regulation, which established a national target for the reduction of greenhouse gas emissions in each member state, Petroleum Act 1988, and the climate compatibility checkpoint, in addition to things like, of course, the NPPF. So it's against that background that he starts with his analysis, and he begins with a look at the purpose and scheme of EIA. And as I said at the start, the basic scheme is to make sure that the relevant environmental issues in respect of a project are identified and considered at consent stage. And because the directive envisions these things being granted by local or regional authorities, these things, being the EIA incorporated into development consent, the approach has to be appropriate for them. And it's here he goes on, as Matthew's already foreshadowed, to deal with the fact that the striking of a balance, in his view, between the promotion of national economic objectives and the reduction of GHGs in various sectors, the rate of transition towards net zero, are all matters of national policy to be determined by central government. The same applies to discussions with other member states about the methodology for accounting for example, Scope 3 GHG emissions and where they may occur in those other states. So the big picture point, those big picture issues are ones which he did not see a local planning authority is in a position to address in any sensible way. Indeed, I think having seen some of the reactions from LPAs on LinkedIn over the weekend when this first came out, I don't think Lord Sales and Lord Richards are alone in that view. He also formed the view that it was constitutionally inappropriate for an LPA to start undertaking practical decision-making based on its own views of GHGs, which conflict with those of central government decision-makers and its ability to set national policy. The EIA directive was intended to be incorporated into the scheme of decision-making, not cut across that scheme of decision-making. Its purpose isn't to create a general data bank about possible Scope 3 effects, which don't bear on what the LPA, the practical decision-maker, has to do. And in particular, he noted Article 2.2, the recitals, the Brussels Airport case, which I don't have time to recite, but it's effectively the passage relied on is one where the CJEU notes that the 1985 directive, as it then was, doesn't require every single project likely to have significant effects on the environment to be subject to EIA. It's only those in Annexes 1 and Annexes 2. Again, it reflects the fact that there are limits to what this instrument was meant to do. Lord Sales also noted that, frankly, the EU in promulgating the directive had to comply with the principle of proportionality, and there are real concerns that the majority judgment will impose disproportionate costs and burdens on developers and LPAs. And again, having seen some of the reactions on LinkedIn, probably not alone in that view either. So against that general background, he moved on to the text of the EIA, and again, he found support for his view that the what is now the majority judgment simply went too far. He focused on the definition of a project, bearing in mind we're supposed to be examining the effects of the project, and that focused on the specific set of physical works. The environmental effects of those, as he said, of the project, the EIA needed development consent for the project's likely significance effect. The EIA obligation to consult the public concerned was those affected or likely to be affected by the project. The EIA obligation to take account of environmental effects deriving from climate change or accident or disaster was looking at the project specifically. And Lord Sales went through paragraphs 273 to 295 to outline a number of key specific references, again, all about the likely significant effects of the project, all of which tie back to that definition of the project being the specific physical work or intervention in the environment. Against that background, he then took up the relevant case law, EU case law. Well, there's the Abraham case, which looked at the indirect environmental effects from increased use. Sorry, I'll start again. The Abraham case, claimants lived near an airport and objected to the project expanding it for commercial use. The CJEU held that the competent authority had to take account of an increase in the activity at the airport when considering the project. But Lord Sales, the point he extracts from this is it's not simply a but-for causation test. And I know Richard's going to come on and talk about causation in a moment, but they were very, very closely connected with the project in issue. He makes the same point about the Ecologistas case and in relation to Brussels Airport, as I've already outlined. The focus is on the effects closely associated with the operation of the airport and the project. It is not a general freestanding EIA means everything gets taken into account. Turning to the UK case law, Lord Sales thought Squire was distinguishable. As Matthew's outlined, this was a case about the disposal of manure closely connected with the operation of a project, here a poultry farm. And again, Lord Sales says in that case, it was clearly an outcome of the proposed development and its use. So it was an indirect effect of the project, very, very closely connected to the project itself. Moving on to the Kilkenny cheese, effectively whether in assessing the indirect environmental effects of a proposed cheese factory, there had to be assessed the upstream indirect environmental effects of effectively needing a lot more cows to produce the milk for the cheese. Those cows fart, methane has climate change effects. The court, in that case, the Supreme Court of Ireland, rejected the idea that indirect effect had an open-ended meaning that could cover any effect associated with the project, not of the project. That would have no limits, would be incompatible with the role of an LPA, and is not in line with the language or purpose of the directive. That's what the Supreme Court of Ireland said, and Lord Sales effectively agreed. They then turned to other authorities and the parties, particularly a number of claimants and the claimant and a number of interveners cited a number of international law cases, a number of cases arising from international jurisdictions. And again, Lord Sales considered that of little help. So against that background of a close interpretation of the directive and its history and its wording, and having found that most of the cases are relatively little help, but noting that he agreed, or the Kilkenny cheese case largely agreed with his analysis, Lord Sales turned to the various other judgments in issue. So he started with Moylan, and Moylan, in the dissent in the Court of Appeal, he thought had over-relied on the reference to for commercial purposes in Annex 1 of point 14 of the directive. Effectively, Lord Sales going through it says there's no, given that the directive is solely focused on indirect effects of the project, there is nothing in the history of for commercial purposes in that insertion to indicate that this particular bit was intended to be special or have a different, wider effect of EIA. So he felt Moylan had gone too far. Turning to the majority of the Court of Appeal, he thought it was unsatisfactory. It's one of the few things that the majority and minority agreed on in this case. The big concern for Lord Sales and Lord Richards here was that the idea that you could have such inconsistent decision-making between LPAs. In many cases, he said that whether an environmental effect is sufficiently connected with a project will be a matter of judgment, in accordance with the line of Blewett and West case law that we're all familiar with. But in some cases, it's so fundamental, the question will be so fundamental the operation of the EIA directive, and so clearly framed that only one answer can lawfully, rationally be given. He thought this was such a case. And in effect, that's where he comes to the reasoning of Mr. Justice Holgate. And he said, soon to be Lord Justice Holgate, as Matthew says, and the dissent here said, effectively, on a fundamental issue like this, there's only one proper answer that can lawfully and rationally be given. And that was that the Scope 3 emissions are not an effect of this project. He then came on to address a point that was raised by effectively whether something can be excluded from EIA, but included as a material planning consideration. He thought Lord Sales and Lord Richards effectively felt there was no issue with that. What's a material consideration in planning terms is one thing. National policy clearly falls within that. What is an indirect effect, or what falls within the scope of EIA, the specific statutory regime, specific statutory instrument, is something else. So he ends the dissent effectively by citing Lord Bingham, who in turn cited Shakespeare, making the fundamental point that whilst the EIA directive and what it's focused on is a matter of real importance, effectively while climate change is a matter of real importance, the EIA directive is not intended to offer relief from the heartache and the 1,000 natural shocks that flesh is heir to. It doesn't do everything. It's got limits. It's a statutory instrument. They all have limits. And what is now the majority judgment, Lord Sales thought, and Lord Richards agreed, simply went too far. So that's my summary of the dissent, and I think we're now going to move on to Richard.
Thank you, Nick. Richard is now going to deal with one of two groups of papers. The slide seems to have gone awry there. Never mind. Richard's going to deal with the critical issue of causation and transboundary effects, and I'll then come on and deal with some other implications. Richard will be known to all. He has been a well-known junior, and now, as of 2024, one of our newest silks. He was a member of the A panel for the Attorney General for 6 years before taking silk. He was Planning and Land Use Junior of the Year at the Legal 500 Bar Awards last year. He does work for private developers, central and local government, public bodies and public interest groups, and has acted for the government in many of the most significant planning and environmental cases over the last 5 years, including acting for the Secretary of State in the Supreme Court and Court of Appeal in Finch. And of course, he led Nick in the Fry case on habitats, subsequent approvals and appropriate assessment, which was handed down at 4 o'clock on Friday afternoon, which of course spiced up our weekends. Richard, as I say, is going to speak on the critical question of causation. Thank you.
Thank you, David, and good morning, everyone. I'm going to look at what the majority said about both causation and transboundary effects. And in doing so, I hope to give some guidance about how the judgment might apply in other situations. The starting point is the wording of the legislation. Regulation 18.3b of the EIA regulations provides that an ES must include a description of the likely significant effects of the proposed development on the environment. That's then elaborated in Schedule 4, Paragraph 5, which tells us that the description of likely significant effects has to cover a whole raft of things, the direct effects and any indirect, secondary, cumulative, transboundary, short-term, medium-term and long-term, permanent and temporary, positive and negative effects of the development. That's an all-encompassing list. The keywords, the three keywords in that legislation are likely, significant and effect. As we've heard, Finch was ultimately a case about the meaning of effect, but the judgment makes a number of really important points about the meaning of likely, or at least the application of likely and significant. And in my view, those are considerable limiting factors on the scope of the Finch judgment. There is no definition of effect in the legislation, and so the majority held that it's a question of law for the court. Ultimately, it's a question of causation. $64,000 question is, what is the test of causation here? The majority discussed three possible tests. At the lowest end of the spectrum is the but-for test, which lawyers will be familiar with. If you apply that test, you ask, would X have occurred but for Y happening? At the top end of the spectrum is a much stricter test of causation, looking at whether something is a necessary and sufficient cause. Here, X has to be both necessary and sufficient to cause Y for causation to be established. Somewhere in the middle of those is a test which looks at intervening steps or acts and whether they break the chain of causation. And Lord Leggatt drew on the House of Lords decision in Empress Car Company, which was a pollution control case, which asked whether those intervening acts or steps were ordinary, in which case they wouldn't break the chain of causation, or whether they were extraordinary, unusual occurrences, in which case they would. On the facts, none of that really mattered because the combustion emissions were agreed to be inevitable. The oil was going to be extracted, it would be burned, inevitably the GHG emissions would occur. So all of those three different tests would have been satisfied on the facts. That meant the Supreme Court did not have to decide and didn't decide which was the correct test of causation. This leaves a degree of uncertainty. I think my view is that the majority seemed to prefer the Empress Car approach. Lord Leggatt also pointed out that it's a test of causation used in insurance law as well. He seemed to think that necessary and sufficient cause would be too strict. I think impliedly suggested that but-for causation would be too weak. However, because the court didn't come off the fence and decide which of those three tests of causation applies, in another case where an effect is not inevitable, there is a degree of legal risk because there's uncertainty about the test for causation. So where you have a case where but-for causation would be established, there is a risk for a decision maker not treating a putative effect as an effect in law. So if what is an effect is a question of law for the courts, does that rob decision makers of all of their discretion and create a big judicial review risk going forward? I don't think it does, because the majority emphasised some important caveats. And the first of those was the principle that causation is established by evidence and not by speculation. And so at paragraph 74, Lord Leggatt said that to determine that a potential effect is likely requires evidence on which to base such a determination, and that if evidence is lacking, so that a possible future occurrence is a matter of speculation or conjecture, then a rational person would not feel able to judge that it is likely. And as I've said on the slide, this means where there's too little knowledge on which to base a judgment, the decision maker won't be required to speculate when carrying out EIA. Lord Leggatt reinforced this at paragraph 77, firmly declaring that conjecture and speculation have no place in the EIA process. So the second caveat is that it does remain, even post-Finch, for the evaluative judgment of the decision maker whether an effect is likely and whether it is capable of assessment. And Lord Leggatt made that clear in his paragraph 78, which I've put on the slide. Now, a decision maker's view on whether an effect is likely or capable of measurement is, of course, challengeable on conventional public law grounds, but in practice, decision makers will have a very wide discretionary area of judgment, and the courts will only intervene if a decision maker's view on those questions is irrational in a public law sense. So what then of other cases? The key question is whether the ruling in Finch has much wider ramifications. I imagine that's why many of you have joined this morning's webinar. We get some clues from the hypothetical examples that were discussed both by Mr. Justice Holgate at first instance and by the Supreme Court. The first example was of a facility manufacturing steel. And the majority said this would not need to assess the downstream combustion emissions resulting from the use of products made from the steel that was being manufactured in that facility. And Lord Leggatt gave two reasons in his paragraph 121 for this. First, he said that the manufacture of the steel is far from sufficient to bring about the effects. Secondly, he said that the future use of the steel is too indeterminate to identify effects as being likely or to make a meaningful assessment of them. And I've underlined the relevant parts of paragraph 121 there on the slide. But what if we change the facts slightly and our factory, instead of manufacturing steel, is now manufacturing petrol engine cars? I think in that example, the future use would not be indeterminate in the sense that we would know that the cars would be driven, and when driven, they would produce combustion emissions. So I think Lord Leggatt's first reason for excluding assessment would not apply to that hypothetical. But questions may still remain about whether a meaningful assessment is possible that does not descend into impermissible speculation. What mileage and lifespan should be assumed for the cars that are produced? How many years of production should be assumed from the facility? What quantity of production per annum should be assumed? Take another example. What if the end use of the steel from the factory were known? Again, it may be that the future use could not be described as indeterminate, so Lord Leggatt's first reason for exclusion would fall away. But again, it could be difficult to decide what is likely as a result of the eventual use of the steel without conjecture or speculation. The second hypothetical example discussed was a factory manufacturing component parts for example, the construction of a motor vehicle or aircraft. And again, Lord Leggatt, this time in paragraph 122, gave two reasons why an application for such a factory would not need to assess the downstream combustion emissions from the end use of the product made from these components. First, he said that the contribution the component makes may be not material enough to justify attributing the impact on the environment to the end product, to the activity of manufacturing. So the widget that goes in the aircraft may be so insignificant, one shouldn't attribute all the greenhouse gas emissions from using the aircraft to that particular component widget part. His second reason was that the number of vehicles that may be produced and their future use may be so conjectural that no realistic estimate could be made of combustion emissions. Again, we can change the hypothetical example slightly to see where the boundaries of the judgment might fall. What about a factory where the component being manufactured is the internal combustion engine, which is key to the operation of the end product? In that sort of example, it may well be reasonable to attribute the impact on the environment to the engine out of which the combustion emissions will emanate. But it may still be conjectural how many vehicles will be produced, how they will be used. So again, bearing in mind what Lord Leggatt said about not speculating and conjecturing in EIA, it may be that that type of example still it's not reasonable to require an assessment. There's a slight tension here because EIA practitioners are well used to making assessments on the basis of reasonable worst case scenarios. Does that mean that we should all just overcome uncertainty by assuming a worst case based on maximum parameters, for example, the maximum output from a factory, average usage of the motor vehicles produced? I don't think it does, because Lord Leggatt's comments about EIA not involving speculation or conjecture, although they don't expressly deal with how that sits with the practice of reasonable worst case scenarios, he is making a fundamental point about the nature of EIA. The ultimate point he's making is that EIA is meant to inform a reasoned conclusion on the application. And if the input from the EIA is conjectural or speculative, that is not something on which a reasoned conclusion can be based. My own view is that Lord Leggatt's comments are highly relevant to what is a reasonable worst case scenario. Any scenario that does involve undue speculation or conjecture is not a reasonable one to assess, bearing in mind his fundamental point about the purpose of gathering the information being to inform a reasoned conclusion. And I think that will be the case, especially where there is no useful or established methodology for assessing an effect. Now, of course, in Finch, there was a well-established methodology for assessing ultimate greenhouse gas emissions from the combustion of oil. But in other scenarios, there may not be a useful or an agreed methodology. But I expect this will be the next main area of litigation, testing when decision makers can say either that an effect is not likely because it is too speculative on the evidence, or that there is no reasonable possibility of carrying out an assessment and producing a realistic estimate. So to conclude on causation, I think Finch is not just about fossil fuel extraction. It concerned a key concept in the legislation, i.e. the meaning of effect. There is an increased risk of judicial review because that is a question of law ultimately for the court. And as I said, because the precise test for causation is unclear. Is it but for, or is it the intermediary test? I think we can safely assume it's not the necessary and sufficient higher test. But despite that, I do think there's a significant measure of flexibility still, because there is judgment involved, subject to rationality review, in deciding whether an effect is likely, whether it can be assessed, and also whether it is significant. So it may, sort of practical advice for decision makers, it may well be pragmatic to assess an impact and note any uncertainties and methodological difficulties, rather than deal with a legal challenge, which could take years, bearing in mind that the Supreme Court's decision in Finch was 5.5 years after the scoping report. So simply assessing may be the path of least resistance. But where there is either genuine difficulty in carrying out an assessment, or where a supposedly conjectural assessment may adversely affect the planning merits, there may well be merits in relying on what Lord Leggatt says about not speculating and putting forward an argument that an effect is not likely, or that it's not reasonable to assess it on a conjectural worst case scenario. Finally, then, on transboundary effects, the majority judgment makes some very important points that limit, in my view, the consultation requirements where an effect is outside the UK's territory. So they said that the obligations in Article 7 of the directive are not triggered by an awareness that as a consequence of a project in one member state, greenhouse gas emissions will occur in another member state. They construed Article 7 narrowly and said that to avoid it being a sort of an absurd process, effects on the environment which are specific to a member state must be shown, rather than purely global effects. So where one's dealing with greenhouse gas emissions, the effect on the environment is of a global nature. It doesn't affect one member state more than any other. And so those downstream greenhouse gas emissions aren't transboundary effects, and decision makers don't need to follow the elaborate transboundary consultation procedures with other member states. So I think that's an important limitation. It prevents the consultation process becoming unwieldy. It's important to bear in mind that that's not exclusive to greenhouse gas emissions. There may be other environmental effects which, although undoubtedly affecting the environment, can't be attributed to an individual or a group of other member states. They are effects on the environment globally, and those two wouldn't need to engage the transboundary effect consultation procedures. That's what I wanted to say about causation and transboundary effects. I think the headline message is Finch has changed the law, it's created uncertainty, but there's a lot in the majority's judgment which attempts to keep that within sensible bounds. There will inevitably be litigation to test what those sensible boundaries are. I'm going to hand over to David now, who's going to talk a bit more about some of the implications for the actual ultimate planning decision, whether to grant permission or not.
Thanks very much, Richard. We've had lots of questions coming in, unsurprisingly. I've tried to field some of those earlier ones while I had a moment, but if the panel would please look at the rest while I'm speaking. Right. Just get hold of the slides. Richard's already dealt with issues 1 and 2, and I'm going to deal with other implications. Firstly, just to highlight the competing views in terms of the practicalities. And one of the difficulties with Lord Leggatt and the majority's view is, while accepting, as you'll see at 105, that there are no measures within the control of the developer which would avoid or reduce combustion emissions. In other words, downstream emissions of greenhouse gases is beyond the control of an operator extracting oil from wells. And the same, I suppose, would be true of gas extraction and other similar fossil fuels. The key point, so far as the majority were concerned, was that the information would be provided even if there were no measures which could be taken to mitigate the environmental effects. And therefore, it's an interesting proposition, as you see in 103, that the combustion emissions are said to be manifestly not out with the control of the site operators. They clearly were outside their control, and that was the reason, albeit flawed as we now know, given in the environmental statement, for only considering the direct emissions from the process, that is to say, the operation of the extraction and the vehicles associated with taking the oil off-site. It's something about which Lord Sales has a great deal to say, as Nick has already touched on. And Lord Sales' position is the far more pragmatic one. You may think, from a judge more experienced in these matters than the majority. I couldn't possibly comment. He says the basic purpose of the directive is to ensure that relevant environmental issues identified and taken into account, in particular with a view as to whether they can be avoided or mitigated. And he goes on to say that it's a matter which has to be dealt with at the level of national policy and indeed legislation, a matter which Mr. Justice Holgate went into in some detail in his first instance judgment. And he says these are big picture issues which are outside the control of a local planning authority. And he goes on to say it would be constitutionally inappropriate for a local planning authority to assume practical decision making on the basis of its own view about indirect downstream emissions and how you'd address them in terms of conflict with central government decision making and national policy. He says, again, the information's there to enable an informed decision to be made and to have practical implications, not merely, oh, well, we have the information. And he deals head on with the point in 258. It's difficult to see in practical terms what a local authority is supposed to do with general information about downstream emissions, other to say, in its opinion, they're so great it oughtn't to proceed at all and to refute planning permission. That he regarded as unjustified disruption of the proper decision-making hierarchy contemplated by the EIA directive. And indeed, that echoes something that the Court of Appeal recently said in the Sizewell C challenge at the beginning of the year, where, again, Sir Keith Lindblom agreeing with Mr. Justice Holgate at first instance. This is on water capacity issues, drew a distinction between measures to be taken by a water company to improve water capacity and the planning decision, and said it would be unduly stultified for the planning process to have to do this. So you've got this sort of distinction between what is actually potential information and what might be material in a broader planning sense, and the issue about, well, what are you actually supposed to do about it and what impact does it have on the planning system? So where does that leave planning authorities? Richard's already touched on some of this. There's little that can be done in the case of fossil fuel extraction and downstream emissions, as even Lord Leggatt and the majority accepted. The only issue is it so bad that you have to refuse it? And the simple question is, in the majority, if not all the cases that come before planning authorities and indeed the Secretary of State on appeal, the contribution of greenhouse gases is relatively small and insignificant. It contributes to a bigger picture, but how you balance that is much more difficult. It's not simply, Lord Sale says, a question of gathering information. So the fact that it may have no ultimate ramifications in terms of the actual form of the consent isn't a reason for not undertaking EIA on the view of the majority. So you ask yourself a number of potential questions. Can the downstream effects be controlled or mitigated by lawful imposition of conditions or obligations? Well, in the case of the extractive industry, probably not, other than those directly related to the process itself. How do the emissions impact on national policy regarding mitigation of climate change and progress to net zero? So something I'm going to come back to in relation to a later case. On current policy, as you will be aware, energy resilience and the continuing need for fossil fuels is a matter of weight to weigh against climate change considerations. Thirdly, are the emissions so great permission should be refused? And you then, and this echoes Lord Sales, by what metric is the planning authority able to judge this when emissions on a national or global scale are matter for national authorities or international agreement or other statutory powers, such as emissions trading and that sort of thing? It's again an issue which is considered in a subsequent case to a limited extent. Perhaps the only thing that can be done, and this was coming up to the Protect Dunsfold case, it's another case involving Sarah Finch, is to consider the issue of greenhouse gases, their scope in the particular case, and how it plays in terms of the issue of energy resilience versus trying to mitigate or eliminate climate change requirements. Of course, if it's not a fuel-based issue, then other policy considerations may have to come into the balance to weigh against the climate change ones. Where the development doesn't concern fossil fuels, there may be more scope for flexibility. And Richard has explained, of course, that this isn't supposed to be an exercise in speculation, but evidence-based methodology as to the extent to which greenhouse gases will be emitted. But I raise a number of questions. What about a developer of a petrol filling station, which undoubtedly has downstream greenhouse gas emissions? Can the local authority, I ask this rhetorically because I think the answer is obviously no, condition the development so the facility doesn't supply fossil fuels and only provides electric charging points or for hydrogen fuel? In the current climate, the answer is no. Can the developer of a plant for building vehicles using fossil fuels be lawfully conditioned to build only electrical or hydrogen-powered cars or limit its production? Again, on current policy, I would suggest the answer is no. What about transport infrastructure, road building? These appear to be matters which go well beyond normal planning control and require legislative intervention or radical policy change. Richard has made very clear the majority seek to put some cap on this sort of wider effect by saying, well, you need evidence because you have to demonstrate a likely significant effect and not merely speculate. But with a number of these matters, for example, with transport infrastructure, the Highways Authority promoting the scheme is going to have some idea about traffic projections to justify the building of a road scheme or a bypass or whatever it is. Similarly, it may be possible to do estimates for throughput based on business planning for petrol filling stations. The fact that there may be some uncertainty involved isn't, in my view, a reason for eliminating environmental assessment at all if there is some credible methodology to assessing likely significant effects. And as Richard said, this is where the next battleground is likely to be. Bearing in mind that Schedule 4 to the regulations allows you to state where there are methodological inadequacies or uncertainties. It doesn't give you a get out of jail free card in all cases, unless it is purely speculative, of course. If you can make a reasonable attempt at assessing likely significant effects, then you should do so, albeit qualifying it. And an example which came in the Q&As while others were speaking was the approach which is now taken to energy from waste and the calculation of whole life emissions from such a plant. And the methodology seems fairly clear, and I'm certainly familiar with it, having done two schemes recently where that has been the evidence, and you look at the emissions over the lifetime of the plant. Of course, there are uncertainties because it all depends on what happens in terms of net zero policy and the removal of fossil fuels from energy generation. But those uncertainties can be explained consistent with Schedule 4 to the regulations. So that's an example of where the methodology does allow you to undertake a whole life assessment of emissions and query to what extent that approach should be mirrored in other cases. I was going to mention the Protect Dunsfold case. This was a case, in fact, the same client, albeit using a different corporate vehicle, same client as for Finch. This is an exploratory oil well just outside the AONB in Loxley near Dunsfold in Surrey. In this case, the County Council had refused permission. The main issue on climate change was the tension between climate change policy and energy resilience policy. Armed with concerns about Finch going on appeal, a greenhouse gas assessment, an emissions assessment was done not merely for the process, but for downstream emissions as well. And that was put into evidence. It wasn't challenged. No one asked questions about it, even Mrs. Finch. And the issue was the alleged conflict between that and climate change policy. The Secretary of State agreed with the inspector that the energy resilience issues outweighed the climate change considerations in that case, but it was challenged because, ironically or unfortunately, on the same day the Secretary of State issued the Loxley decision, he also issued a decision at Ellesmere Port, which refused permission for a scheme which had almost identical downstream greenhouse gas emissions. However, the challenge failed before Mrs. Justice Steyn, but it did highlight the importance of the policy context. And I've just quoted a little bit from the judgment. There was a specific policy context there which was considered to be relevant, where the Cheshire Authority was specifically trying to drive down local emissions below a certain limit, which gave rise to difficulties here. But in any event, there were a number of differences between this and Loxley, and Mrs. Justice Steyn refused the judicial review, and it was then refused permission to appeal on the paper. So a critical issue which greenhouse gas emissions and downstream assessments is likely to give rise to is the continuing tension between the need for continuing energy and fuel pending major changes in use and technology and changes to more carbon neutral means. And it will depend very much on the trajectory of national policy and the practicality of undertaking such alternatives. Fossil fuels appears to be a reactive position, as I've already indicated. Clearly, other downstream effects are capable of being required to be assessed, since EIA, of course, isn't limited to assessing indirect effects from greenhouse gas emissions. There are a whole variety of forms of impact. However, as Richard has indicated, these have to be capable of being assessed at least to some degree, subject to the caveat about difficulties with the methodology predicting precise numbers, and that is likely to cause rise to some difficulties. And of course, the balancing of issues and policies, that is to say, emissions and climate change, net zero, versus whatever policy is supporting the particular development, will of course be different depending on the form of development. But the thing that concerns me most is that authorities are going to be struggling with Finch in terms of what they do practically when faced with an EIA development, and avoiding the risk of judicial review. It does leave, following Richard's paper, the practical problem of actually assessing the impact of greenhouse gases and other possible downstream effects, highlighting the difficulties I've already mentioned. It is certainly possible in some cases. Energy from waste is one of them. It becomes much more difficult and therefore easier to rule out in some cases, because there may be no clear causal link on any of the tests with downstream emissions because of the nature of the development. And Richard's given you some examples. What if you've got steel, which is going into a vehicle plant to build fossil fuel emitting vehicles? It leaves us in a difficult position. And I end just with the thought of, well, what happened to what the then Lord Justice Carnwath said in Mansfield? It's intended to be an aid to efficient and inclusive decision-making, not an obstacle race. And perhaps more pertinently, Mr. Justice Sullivan in Blewett, an approach which has been echoed many, many times, including on at least 2 or 3 occasions by the Supreme Court or the former House of Lords. It is of no advantage to anyone if environmental statements are drafted on a purely defensive basis, mentioning every possible scrap of environmental information, just in case someone might consider it significant at a later stage. That would be a hindrance, not an aid to sound decision-making. And you can hear echoes of that in Lord Sale's dissent. However, where we are is the uncertainty, particularly with the question of likely significant effect. Can you assess, or is it too speculative? Which local authorities are going to struggle with, and is definitely going to have to be looked at on a case-by-case basis. Someone suggested in one of the Q&As, well, is Lord Leggatt really obiter because it was inevitable in that case? I'm afraid I don't think that's right, because the reasoning that gets him to that position, Kantian philosophical concepts aside, gives rise to this issue. And it is the question of what count as indirect effects, not simply greenhouse gases, which is the wider question which we're all going to be struggling with over the next couple of years, subject, of course, to any amendments to the law made, either in the context of the existing LURA or any legislation which an incoming government might wish to bring. Thank you very much for that. And if we now turn to some questions, and we've got 13 currently unanswered. Can I start? Richard, can I ask you with the question? We're asked about the implications of sand and gravel extraction, either upstream or downstream. Do you have any views about that?
Yes, I mean, I think this particularly arises in the context of extraction of aggregates in order to produce concrete, because concrete is quite a large GHG emitter. To some extent, it's going to depend on the facts of each case. First question will be, is the downstream effect likely? So is the future use of the aggregate that's being extracted definitely going to be for cement production? If not, I think there's room for judgment to say that that's not a likely effect. But if we know the aggregate is going to produce concrete, The next question is it reasonable to attribute the effect of the cement manufacture to the extraction of the mineral? And that's a value judgment ultimately for review by the court. It may be that the decision maker would decide that there is a core ingredient of the cement, and so it is reasonable to attribute the effect to the extraction. Then you get questions about conjecture. How can we, is there a methodology for deciding what the emissions are? It's a way removed from fossil fuel extraction, but one can easily see how extracting minerals to produce cement could be required to assess the downstream emissions of the cement manufacturer as well. But there are certainly room for argument on the facts.
Thanks, Richard. Nick or Matthew, do either of you wish to give a view about the implications of Finch for SEA, Strategic Environmental Assessment?
I'm happy to field that question. I think it's in my view, it's likely that in a local plan scenario, the same type of assessment would need to be taking place as in EIA, notwithstanding the fact that obviously it's at a slightly higher level, potentially a broader strategic level. But if you have, for example, a draft allocation for a oil extraction site in the plan, it's probably be a mineral plan as opposed to a local plan of a different kind, that you would need to, as per Finch, carry out an assessment of the likely downstream effects. And it may be, of course, that when you subsequently have an application for planning permission pursuant to that allocation, that the EIA that is undertaken has to be refined to an extent, depending on the specifics of the proposal that's being brought forward in accordance with the allocation. But certainly there would need to be an initial assessment at the local plan stage.
Just throwing it out there, I mean, what about an allocation for a large urban extension for housing and the like, where, for example, the allocation doesn't require ground source heat pumps or something of that description?
I think that's quite a difficult question, frankly. I think this is in the realms of the kind of sensitive boundaries that will be tested as a result of Finch. I'm not sure I've got an answer to that one at the moment, David.
Well, I was just thinking, because there's an argument raging, certainly within the scope of the general election, about when you phase out gas boilers, for example, and you may have solid fuel burning, either wood or coal, although less, not really coal these days, but you still have the wood burner debate, and also oil central heating. There's some scope for that, but I suppose it comes down to methodology again, doesn't it? And how do you assess it?
Yep, agreed.
Right, Nick, I'll throw one at you actually. What about other regimes? I mean, there's a tension in the majority and the minority about this, but what about how does this interact with the fact that it's been established planning policy for many years that planning doesn't need to regulate something which is subject to another regime? Does that impact at all on what you undertake by way of EIA?
I don't think it does. I mean, the EIA question is separate from, it feeds into, but it's technically separate from the overall planning question. So it doesn't change, I don't think, what you have to sort of take into account as a matter of EIA in terms of the downstream emissions. You then get the more complicated question, which is, well, can we rely on the Climate Change Act and the other regimes to effectively curtail this, or to assume that actually, even if it's predicted that this particular development will exclude 20 billion tons of CO2, that's not compatible with the Climate Change Act 2008, so we can make some sort of planning assumption that it won't. It's a really knotty question. Actually, I don't really see an answer to it. I think the EIA question will probably stand on its own. I can see the potential for there being a fight over whether, whilst it's established planning policy that you can assume other regimes will operate effectively, that's a presumption and assumption. The case law it's based on is a presumption and an assumption. So I imagine one of the fights we'll see going forward is objectors saying, well, it's not operating effectively. We don't think it's going to operate effectively, and trying to do away with that presumption entirely in a given case. I imagine that's what they'll fight. I don't know if it'll be particularly effective. So I'm afraid, again, I don't have much like one of Matthew's last answers. I don't have a clear answer to this yet, personally.
One question that I'll answer, which is, what if it's already been assessed, or it's going to EIA is going to have to be taken out for a subsequent stage in the process? And the short answer to that is Lord Leggatt was quite unconcerned about the fact you may have to assess emissions at different stages in the project. The mere fact that you may be duplicating in part the exercise does not appear, in the view of the majority, to be a reason for excluding them from the specific project EIA, because we did press on him quite hard the fact that the oil had to go to refinery. The refinery would have to be subject to planning permission and permitting, and would have to be subject to EIA. I think refineries are Schedule 1 projects, but that didn't seem to cut any ice with the majority. So the answer is the fact you may have done it already, or had it done already, doesn't stop the obligation.
David, that also has relevance, I think, to cumulative effects. So when one is looking at which other projects you need to assess in combination with yours, if there's a causal nexus now between more things downstream or upstream, they may need to be brought into the cumulative assessment, whereas perhaps pre-Finch they wouldn't.
I mean, there are a number of questions which say, does this go beyond EIA? And I think for present purposes, this is an EIA decision, and it's a decision based on the construction of the regulations and the preceding directive. It's not a general climate change judgment. It's and how to deal with it. It's a question of what you do in terms of assessing the scope of the likely significant effect by indirect emissions under EIA. Do you agree with that?
I do. I mean, both the majority and minority were very clear. They were construing the words in the legislation, particularly the meaning of effect. Lord Leggatt's clear when he's looking at causation that you approach causation purposively, and so it's the purpose of the EIA legislation and the language that the court ultimately was concerned with. So you can see a clear read over to SEA, because the word effect appears in that legislation. The broad purpose of early assessment to determine effects and informed decisions is the same. So I can readily see a spill over to SEA, but beyond that, I think it turns on the language and the purpose of the legislation.
Yes. In terms of upstream effects, and we've had and you've already mentioned that in the context of aggregates and concrete making. What about the manufacture of ostensibly carbon-friendly power generating infrastructure, the manufacture of wind turbines, or indeed solar panels, which may require the extraction of minerals from sensitive locations and that sort of issue? Do you have any views about assessment of upstream effects for manufacturing for those items, even though ostensibly they are carbon neutral?
And I think it's extremely difficult. The court looked at upstream only in the context of Kilkenny cheese. So strictly nothing in Finch is directly on point looking at upstream impacts. I mean, I think there's a good argument that you look at both the positive and the negative. I mean, the directive is clear. I put the text on one of my slides. You look at the positive and the negative impacts. So the mere fact there are positive impacts because the ultimate end product is going to be carbon beneficial potentially isn't a reason not to exclude it. It's a reason to include it and highlight the benefits.
Yes, and I suppose if you're talking about this sort of thing, the manufacture of electric vehicles have been criticised in terms of how long on a sort of whole life carbon assessment it takes to actually get a carbon neutral outlook. You know, perhaps the use of rare earth minerals in some of the software and in some of the hardware which drives the car, and the manufacture of the batteries. Yeah. Because Kilkenny cheese was very definitely an upstream effect. It was the methane produced by the cows needed to generate the milk to produce the cheese, and the Supreme Court were dismissive of the approach of the Irish Supreme Court in that case. So it does seem to be implied that upstream effects clearly are up for grabs in terms of indirect effects as well. Nick or Matthew, do you have a view about about the effects in terms of climate change or other effects of decommissioning of plant, and does that have to be assessed at the earlier stage?
For my part, I think it probably does. If decommissioning is an inevitable stage of the process, which it probably is when you're talking about something like certainly solar panels, then I can't see why, if you know that the decommissioning stage is going to arrive and there are going to be inevitable effects of it, you would be able to exclude that from your EIA. So I think it probably does. It does fall to be included.
And Nick and Richard, bearing in mind you're currently wearing your We Won Fry trophy from Friday afternoon, which generated a lot of puns about "Thank God it's Friday" last week. But let's not worry about that. There is a serious question: are there implications for habitats regs assessment, either screening or appropriate assessment, in terms of Finch?
I think not directly, because, as I said, this was a case construing the EIA regs.
Yes.
I think what one can take, though, is that, I mean, there is a question of causation in habitats. Ultimately, you're looking at the effect on a particular protected site and whether a plan or project will affect it. Lord Leggatt tells us that that's ultimately a question of causation, and the test should be purposive. Where you've got the habitats regs, which are on a strict precautionary approach, one would expect a test of causation that brings more effects into assessment than excludes them. So I would say, but for causation is arguably the correct test in habitats because of the precautionary of the regime.
Yes, I mean it is a very high hurdle to overcome, and although Lord Carnwath Champion, endorsing Advocate General Cocotte in the Wadensee case, said it's not an absolute test, it is still a very high test. Finally, infrastructure, and I think we covered some of that, both you and I, Richard, in terms of roads and the like. What about airport projects and Scope 3 emissions from aircraft?
Yeah, I mean, this is sort of Abraham's, really. I don't think there's anything new about this. It's been case law of the Court of Justice for some time that when one constructs a project, in Abraham's it was an extended runway at an airport, you need to assess not only the construction impact but also the impact of using it. So that would include a road. Commission in Spain was about a railway. So providing there's a methodology to assess on reasonable estimates the future use of your infrastructure, it's well established that that's already something that one has to assess.
Yes, unless you're just relicensing the airport in the Brussels airport case, in which case it's not a project.
There was quite a lot of reliance on Abraham by Mrs. Finch, and it's interesting to note that Lord Leggatt, in the majority judgment of paragraph 159, basically says Abraham is a very different situation to what's being dealt with here, so doesn't get a lot of assistance from it.
But doesn't actually explain how it fits in with his approach to causation, which is the difficulty. Very well. We're just coming up to 10 o'clock. Can I thank everybody for their attendance, and we hope you found this useful.